Mr. Murray in a more advantageous position now, so that should be helpful. Go ahead. There you go. Okay. Go ahead and raise your right hand. You swear or affirm the testimony you are about to provide is true and accurate?
I do.
Thank you.
Thank you, Mr. Chair. Mr. Skilling, can you please state your name for the record?
David Charles Skilling.
And in these proceedings on July 14, 2023, did you cause to be filed written direct testimony?
I did.
And was that testimony accompanied by Exhibits 1 and 2?
It was.
Do you have any corrections or clarifications?
I do.
What is your first clarification?
My first clarification is discussion about ingress and egress and roadways.
Okay. If I could perhaps have the tech bring up page 5 of your testimony. Okay, so going down to the section beginning on line 63, that area references a 40-acre property, correct?
Yes, it does.
Okay, so is the ingress egress you're speaking of reference that quote property, end quote?
It does.
Okay. So to further help you as far as clarifying the ingress egress issue, can I have the tech expert bring up DAPEMA hearing exhibit 2? Okay. This has been entered into evidence already as DAPEMA hearing exhibit 2, Mr. Skilling. Is the shaded parcel the 40-acre property that we're talking about?
That is correct. Yes, it is.
Okay. To your understanding, this is the property that DAPEMA owns, which is affected by this action.
That's correct.
Okay. What do you want to clarify about the ingress egress?
What I'd like to clarify is the fact that if you look at that property on the east side, you will note there's a gravel road. I do this right. There's a gravel road along that portion. And if you could raise that, if you would, please. Down at the bottom, you'll see a blacktop. And as you can see, we've got a parcel of property that is somewhat landlocked. And one of the things that concerns me is my negotiations with Summit is trying to get a explanation of where ingress and egress would be in regards to that property. Like I said, it's an inside 40, and there's no real entryway into that at this point. I have talked to our county engineer, Kossuth County Engineer's office, and while there may be some requests with regard to access ways by Summit, I understand that none of those have been issued yet and potentially will not be discussed or looked at until there's actually been a permit for them to build the pipeline. So as we look at that now, we don't know. We don't know where they're going to throw that, the ingress and egress, and that's a great concern.
Mr. Skilling, just as another point of clarification or at least recollection, using your pointer, can you identify where the pipeline is proposed to be located?
The pipeline
Objection, Your Honor.
State your objection.
This is not what corrections to written testimony are utilized for. A correction or modification to pre-filed written testimony is for something like a typographical error. This is just a direct examination on top of what's already admitted as pre-filed direct testimony. So my objection is we're conducting direct exam here when the purpose of the hearing is for cross-exam.
Mr. Murray.
Just clarifying the record, Your Honor, not adding to it.
Your Honor, if I may briefly respond.
Go ahead.
It would be typical practice for a correction or modification to call out the line and page of the testimony that's being corrected or modified. This is just an invitation for a verbal recitation of what's already in the direct testimony.
Okay, Mr. Murray, corrections are for mistakes or errors in pre-filed testimony. I believe you referenced page 5, line 63. So if we can get to the correction and move on, please.
Mr. Skilling, I think that this page 5 references an Exhibit 2, which is the Exhibit H on your farm, correct?
Yes, that's correct.
All right. Do you have any other clarifications besides this one?
The other clarification would be that there's no showing of ingress and egress.
Since the filing of your testimony, has there been any happenings that have occurred since that time that have affected you as a landowner?
Objection, Your Honor.
State the objection.
I'm going to state the same objection. That does not call for any correction or modification. It, in fact, invites additional direct testimony.
Mr. Murray.
By rule, he was required to file his written testimony on July 14. The evidence that I think he wants to talk about is occurring after July 14. This landowner would like the board to understand about the public necessity argument.
So you're saying it is additional, not a correction?
Supplement is clarification of his public necessity argument, which is in his testimony on page 11 and 12.
Mr. Murray, we're going to sustain that objection. If you wanted additional testimony, you would have needed to ask the board for permission. Thank you.
Thank you. Mr. Skilling, I'm directing you to page 11 and 12 of your testimony. And if the tech could publish that. If we could go down to the bottom there, I believe. Okay, so on page 197, you have a criticism of public purpose.
Line 197, correct?
Line 197.
Sorry, thank you.
Do I reference this part of your testimony correctly?
Objection, Your Honor.
State your objection.
The same objection that was just sustained. Now we're asking him to read his direct testimony, which has been filed and is in evidence.
That I was going to ask him if he had any corrections as to this area of his direct testimony.
Absolutely not.
Okay. I'm going to, if the chair needs to rule on the objection,
I believe you just said there's no correction, so.
Right. So nothing further for this witness.
Thank you. So, do you have any?
We will offer the direct testimony and the exhibits into the record.
Is there objections?
No objection.
Seeing no objections, the board will admit, give the weight due. Tendering the witness?
Yes.
Thank you. Questions from the parties for the witness? Mr. Jorde?
Sir, were you able to listen in to the testimony of Mr. Jimmy Powell and Mr. Peroli that was publicly available?
I had a chance to look at that testimony pursuant to the board's allowance of the live streaming.
And was there anything particularly in those two gentlemen's testimony that in any way causes you to modify any of your opinions or positions from your pre-filed testimony?
Yes.
And what is that?
Oh, I'd like to begin with hearing them talk about the individuals that came before the individuals that would come and visit with us and talk to us about the summit plans for this pipeline. I would like to say that initially, one of the individuals that was responsible for contacting us, Mr. Lauren Peterson, called an attorney's office in Algona, Iowa, the Peterson Lips firm, and wanted information about us from them. The Peterson Lips firm responded that even if they had information, that would be unethical for them to contact us. Then we had Wes Patterson come. Wes Patterson came, talked with my wife, and in respect to that visit, he explained to my wife that, you know, I'm in charge of Hancock County. And in regards to Hancock County, he was about 15 miles into Kossuth. Then finally we had Cody Parkin. And Cody promised and had told us that we could look at ingress and egress would be about around the pipeline area. So what do we see when we get the paperwork filed is we now have Summit and their attorneys seeking easement over an entire 40 acres of property.
So how would you characterize your interactions with Summit and their agents in their attempts to try to get you to execute an easement?
Poorly.
And do you have any concerns that Summit has not made publicly available its risk analysis and the true dangers that this pipeline could pose to you and your community?
Objection, Your Honor.
State the objection.
But again, he's not being cross-examined. He's being subjected to additional direct examination by a party aligned with him.
Mr. Jorde?
Well, 17A.14 in contested cases deals with irrelevant, immaterial, or unduly repetitious evidence, of which that question is neither. And it also states that witnesses at a hearing or persons whose testimony has been submitted in written form, if available, shall be subject to cross-examination by any party as necessary for a full and true disclosure of the facts. Now, those are the rules, not how this may have happened in the past. And this gentleman, like all witnesses, have no opportunity to speak to what Summit's witnesses come and say here that isn't in their testimony, and he needs an opportunity to respond to that.
Your Honor, if I may respond briefly, the rule that Mr. Jorde read permits cross-examination. This is not cross-examination, it's further direct examination.
I'd like a definition of cross-examination then from Mr. Leonard.
I don't think that's really necessary.
Okay, well, cross-examination.
Hold on, we'll rule in a moment. We're going to take a 15-minute break. We're going to talk with the rest of the board. I want to put this issue to bed. Mr. Whippel, did you have anything to add before we go on that matter, or did you just want to get in the queue?
I don't want to get in the queue for this witness. I'd like to add one thing on this point before you go into closed session to discuss it. There are witnesses that the counties would like to examine, and I think some attributes to the other intervening parties a requirement or asserts that we're all always on the same side of an issue, but you know, there are facts that the counties would like to elicit from some witnesses that fit our theory of this case that is different from the other parties. We will try to be respectful of duplicative information, but we would like that opportunity, Your Honor.
So, just clarifying, you're stating the point that, well, in general, your position may not be shared. There are times when you are, quote unquote, friendly to the testifying party, but you want to make a point that you may not be in alignment with that particular party on it.
Well, we may not be opposed and we may not be friendly. We may be trying to develop our own evidence for our own briefing and see some witnesses as useful to elicit those facts. It's not true that there's only Summit's side and the other side. There are everyone's side in the record we're trying to make for briefing and later argument.
Thank you. Mr. Taylor.
Thank you. I don't want to belabor this too much, but a couple of things. One is that I think that when the board uses the vehicle of a written direct testimony, although that puts the facts in issue and so on, it doesn't really bring on all the evidence as the statute Mr. Jorde read envisions, and so I think it is necessary, without unduly being repetitious or irrelevant, to expand on the written testimony. And the other point is just to confirm Mr. Jorde's observation. The cross-examination doesn't necessarily mean cross in the sense of being adverse. It just means examining someone other than your own witness. Thank you.
Mr. Duboski, did you have anything to add there? I see your card up.
I do, Your Honor. Just before the board deliberates on this, I think, to Mr. Whipple's point that, well, there may be a witness that nominally is on the same side of the case in terms of objectives, but we want to get additional testimony for our briefing. Each party had an opportunity to make a direct case, and if there were things they thought they needed for their briefing, they could and should have done that through their own witnesses. And I disagree with Mr. Taylor. I think cross does have a meaning. It doesn't just mean asking questions. It is a different creature from direct examination. And here, I don't think it's that difficult to figure out that most of the interveners, if you read their testimony, if you read their intervention papers, are looking to have the board deny the application. And there may be subtleties within that, but to the extent that they have a similar overall objective, just because there is no V in the caption of this case, like there would be in a traditional two-party, for example, court case, doesn't change the reality of the fact that there is a V here, and cross is for questioning across that V, and that's just simply not how it's being used here. Mr. Jorde's earlier argument that, I apologize, it may have been somebody else, but the earlier argument that, well, there's direct testimony or there was live witness testimony and people haven't had a chance to respond to that, so they ought to get to. In any hearing of any kind, in this board, in a court, there will always be new testimony coming out. And if we always said, well, everybody then gets a response to that, you literally would have this never-ending back and forth, back and forth, back and forth. And that clearly is not how hearings work. There are a limited number of back and forth opportunities, again, that generally so happens that the applicant, the movant, the plaintiff gets the last word in those, and not everybody's always going to get a chance to go in behind that. And that will always be true no matter how many repetitions you have. So at some point, those repetitions simply become, everyone trying to get the last word on something, which is just simply not possible. Again, fundamentally, this is just not cross-examination.
Thank you. Did anybody have any other comments or thoughts on the matter?
Yeah, any party is allowed to ask questions of any witness. That's the rule. It's as simple as that.
May I speak on my behalf?
Fortunately, hold on. Mr. Skilling, you have an attorney.
I do.
This is just a procedural matter, so we traditionally speak through our attorneys. I don't want to tell you no, but this would typically be handled by your attorney.
At the risk of upsetting my client, I think plenty of record's been made on the procedural point.
Mine was going to be something different. And it was not well, it is procedurally, but it isn't. I was going to ask if I could go back and add to some testimony I'd already provided.
Okay, well, we're going to take a 15-minute break, so it'll be a great opportunity to talk to Mr. Murray and see what your avenues and options are there.
All right, thank you very much.
Thank you. Just make sure I didn't miss anybody. Thank you. We'll be back in 15 minutes-ish. Okay. Good morning. Sorry, took a little longer than anticipated. As it relates to the second motion of the day, or the friendly cause, this was foreseeable, and it is not new ground. This issue has been raised. In fact, I believe Sierra Club raised this issue in Dakota Access. District Court clearly and succinctly affirmed the board's ability to limit friendly cross and rely on pre-filed testimony heavily. Mr. Whipple's point is well taken. There are areas of nuance, and I have no doubt the attorneys in the room will explore that nuance, and the board will continue to restrict and run a very tight course. As it relates to Mr. Jorde's initial motion this morning, we said we'd wait till lunch, but we were there and decided to deal with it. As previously stated in at least one order, mere admission of testimony does not waive cross of a witness. Only a motion by the sponsoring party, acquiescence of the other parties, and permission of the board will waive cross. All right. Well, with that, we'll go back to you.
Thank you.
Ms. Colas, do you have a question for the witness, or?
I just have a question for you, Your Honor. One of the questions before you took a recess was when I received my instructions from the IUB board, it said I had the right to cross-examine all witnesses. So you're saying I still have that right?
You, the parties, have a right to cross-examine.
Whenever I feel necessary.
There are restrictions on friendly cross-examination. If questions become unduly repetitious, it is subject to objection and ruling by the party. We are not saying there is no cross-examination. Cross-examination is necessary. We are saying it has become fairly frequent in this hearing that the friendly cross-examination has become unduly repetitious. And we have clear authority to limit unduly repetitious testimony.
Thank you.
Thank you. Okay. Mr. Jorde, I believe it was your witness.
All right. Well, I think we left off with the question relative to any concerns you have, if any, due to the fact that Summit refuses to share its risk analysis and plume modeling with you, the public. Do you have any concerns about that?
I do.
And what are those?
The concerns I have is my property, my wife's property, my son's property that we hold under DAPEMA is in an area where there are quite a few houses. In fact, with regard to our property, we have a renter that lives right across the road, about 1,500 feet from where they want to put the pipeline. And as I stated earlier, to the north, there are other families as they run the pipeline to the west across that property that I believe would be impacted by any type of rupture.
Would you be able to make an intelligent, informed decision on whether or not to sign an easement in this matter without having that safety information to consider?
Excuse me, would you say that again, please?
Do you believe you would be able to make an intelligent and informed decision on whether or not to sign Summit's proposed easements if you do not have and do not know the risk posed to you?
I would not be able to intelligently sign a easement without that information. There's other information I'd like that we just don't seem to get, but
What's the other information?
Well, as I said earlier, they're asking for 40 acres of my land. I'd like to know exactly why they need it when they're only asking roughly 3 acres for the pipeline and the temporary construction easement. I've got a question about why they didn't go to the property owner above us, who is Rothler Trust. Rothler Trust has already signed signed an easement agreement on property that's roughly a mile away from where we are. That the property I'm speaking of right now that affects me is right above my 40 acres, and it would not take much to go ahead and move that pipeline up onto that Rothler property.
Did you suggest an alternative route, and if not, do you have one you can describe?
We did not ask for one. The one I would describe is to go that little bit above where our 40 is and move it north on the Rothler property, where you've already had someone that has gone ahead and signed an easement.
All right, sir. Thank you. I don't have anything further.
Mr. Taylor?
Thank you. In your written testimony, you mentioned an abandoned hog lagoon, and it wasn't clear to me what the issue is there. Can you clarify that?
I can. There is a hog lagoon. There had been a hog setup. It's not being used at the present time. I believe it was about a year and a half ago, or possibly 2, this lagoon started to stink. And the stench was so bad that you could smell it almost into the city of Algona, which was about 5 miles from this lagoon. There was an effort made by individuals to try and drain that lagoon, and in the process of trying to drain that lagoon, an individual died from asphyxiation, and the other individual that was there with him was able to get away, and still, I believe, was hospitalized, or at least went to the emergency room. To my knowledge, that hog lagoon still exists. There is in discussions with who's responsible now. It's been abandoned to see that that gets drained. And I can't tell you how far, but it's in the near vicinity of where this pipeline wants to go.
So how do you see the pipeline impacting that, or that impacting the pipeline?
Risk. In a simple word, risk. If there's any rupture with regard to that pipeline, we've already seen a lagoon that has caused the death. It's highly volatile, and it would just add to the danger again and the risk.
You told Mr. Jorde that there was a house, I think you said to the east, that was 1,500 feet from the pipeline. Is that correct?
The house that we have is south, about 1,500 feet from the pipeline.
And then you said there were some houses to the north. How far would those be from the pipeline?
As it runs west, they're going to be similarly situated. We took a drive out in that area yesterday in preparation for today's hearing, and I believe my wife and I counted at least 3 family homes. And then as you go to the west, there are going to be 2 family homes there's a gravel road on the west side, and one is on the east side of the gravel road. There's another one on the west side.
And the pipeline in Kasuth County goes from east to west, correct?
Correct.
If there were a pipeline rupture, how close is the closest emergency management personnel?
5 miles.
Okay, Is that a small volunteer?
That it is. I might mention the one thing that concerned me too is what I've heard in testimony with regard to safety measures. The fact is that they're going to have someone in Ames, and it kind of reminds me of Chernobyl, that there's going to be a situation where there's going to be something that goes off that's going to indicate, hey, we got a problem. And hopefully there's someone in that place in Ames that's going to be able to make that decision. What are we going to do? And make it immediately. The way I understood the testimony, and I can't tell you who offered it, someone from Summit, but then what they're going to do is relay it to somebody in the area. And then that somebody who's unknown is going to go check this rupture, whatever it might be, and what they're going to do is try and assess it for degree of risk. Is it a major rupture? Is it minor? Well, then they've got to relay it into wherever is the closest party to do that, to come and respond. And there's just too much left unsaid.
That's all the questions I have. Thank you.
Thank you. Oh, thank you, Ms. Hyde. Go ahead.
Christine Hyde, landowner. Sir, do you know how many land agents you've had? I know you mentioned 3 of them, Lauren Peterson, Wes Patterson, and Cody Parkin. Did you have any more than just those 3?
Those are the 3 I can think of. I know there was contact early on that we had gotten call that there was a representative from Summit out on our land surveying it. And we would have been notified about the survey. We were not. And again, some neighbors in that area saw it. My wife drove out there and was in contact with that individual. And there's no real explanation of why he was there. Wes Patterson was in contact with my wife and said no, they had done no surveys yet, and they would do a survey. And my wife asked if we would be notified, and there was no notification, and supposedly someone went out and surveyed it. So we have no idea who in fact surveyed our land. Again, there's just things up in the air.
Could you estimate how many hours you've had to spend on matters related to Summit's proposed pipeline since you first learned that they intended to cross your land?
Excuse me, would you repeat that?
Certainly. Could you estimate how many hours you've had to spend on matters related to Summit's proposed pipeline since you first learned of their intention to cross your land?
It's hard to judge. It's taken a considerable amount of our time. I certainly could ask my attorney, Mr. Murray. He's kept time, and I don't know how long beyond that it's been. My wife and I have done a considerable amount of time on our own, researching, contacting, and doing some other things. So.
Thank you. Has Summit threatened you with eminent domain, either outright or by insinuation, during this whole process?
There's no threats, but it's obvious that that's what they're waiting for. That they're just, the negotiations started out early on. They were asking for an easement over the entire 80 acres we had. As I indicated, we have a stacked 40. And initially they wanted the 40 closest to the road and the 40 at the top. Well, the interesting thing that came out in the easement that was first sent to us said, and it was hidden in the easement, that we also, once you sign this, have access to all adjacent land that is between that north piece we're talking about right now and the roadway. And it was hidden in the easement, and that was our initial concern when we talked to Cody Parkin, and basically Mr. Parkin just told us we were misreading it, and I sorely disagreed with him, and anything after that was just downhill. There was no, as far as I can say, good faith negotiations.
David, did Summit provide you with any paperwork discussing warnings, risks, or safety information related to putting in the pipeline on your property?
They may have, and I just don't recall it.
Is there anything else you'd want to address to the board to let them know as it relates to this pipeline project?
I do. I would like to relate to the board that I don't see any reasonable purpose or rational basis for this pipeline. There's so much that's being left unsaid. We don't know about the plume. We don't know anything about the emergency reaction. We don't know about the insurance. All this is speculation. We go down the line. We don't know about ingress and egress. We don't know if the counties will actually allow permits for access off of the county roads. We hear, and what I have heard is that Summit tells us they're going to do that, but I say to the board, the road to hell is paved with good intentions.
Thank you, David.
You're welcome.
Mr. Murray, just double check it. Hold on. Questions from the board. Did you want it for redirect, Mr. Murray? I don't think there's any other questions, so it's all yours.
If there's no other cost, then yeah, I have one line of redirect. Had to do with Ms. Hayek's reference to the property adjacent, okay?
Yes.
I wanted to ask you some clarification on, explanation on that. If the tech could bring up Mr. Skilling's direct examination, exhibit number 1. Now, on the screen is what appears to be the proposed easement agreement that you identified in your written direct examination, correct?
Correct.
Now, if I could have the tech go down to the bottom of page 2. On the bottom of page 2, there is the heading Access Easement. Do you see that there?
I do.
Now, this was, to be clear, an easement agreement presented to you that you did not sign, correct?
That's correct.
And it says there under Access Easement, a free and unobstructed, non-exclusive easement in, to, through, on, over, under, and across the landowner's property and over the property of landowner adjacent to the easement and lying between the public and private roads and the easement, left parent, the quote, access easement, end quote, right parent, for the purpose of ingress and egress to the pipeline easement I'll stop there. Is that the part that you're referencing when you refer to the language property of landowner adjacent to the easement?
Yes, it is.
That is your concern.
Yes, that would be the southwest quarter of the southwest quarter, I believe, if that's the correct description.
Okay. And if we can go to DAPEMA hearing exhibit number 2, Tech. To be clear, you understand the highlighted area here in the DAPEMA hearing exhibit 2 to be that which is subject to taking, right?
Correct.
But you own the property to the south of there.
Correct.
And the road is south of that.
Correct.
Okay, nothing further.
All right, thank you.
You're welcome. Thank you for your time.